I'm Tony DiResta, and I have the privilege of being the co-chair of Holland & Knight's Consumer Protection Team. By my side is my good friend and partner, DeMorris Cohen, who heads up the advertising practice team here at Holland & Knight. It's a pleasure to be with all of you today. And we have the privilege of being with Michael Ostheimer today, who's going to talk about social media advertising and the social media landscape, testimonials and endorsements, influencer marketing, digital advertising, fake and manipulated reviews, and FTC enforcement. So we have a lot to cover. Let me just give a 30-second overview of Michael's background. He graduated from University of Pennsylvania. He went to Columbia University Law School, where he was the Harlan Fiske Stone Scholar. He's been at the FTC for over 30 years. He was also counsel to the director, and I tend to look at Michael not only as the guru at the FTC when it comes to social media marketing and advertising practices, but DeMorris and I have had the pleasure of working with Michael in investigations, and Michael is just the ideal public servant. He listens. He's quite an astute scholar when it comes to issues, and he's very reasonable. So on all levels, Michael, it's a real pleasure to be with you this morning. Thank you for joining.
Thank you, Tony. It's a pleasure being with you today, too.
Let's just jump right in and start with the proposed revisions, Michael, to the guides on testimonials, endorsements. What's the status right now? Where does that stand?
Well, before I answer that question, I need to give an official disclosure that what I'm saying today reflects my own views and does not reflect the views of the commission or any commissioner. With respect to your question, last July, the commission put out our proposed changes to the endorsement guides for public comment, and we received 30 comments. The next step would be for staff to review the comments and make a recommendation to the commission on what changes, if any, to make to the proposed guides. The commission would then consider staff recommendations and issue final revised guides. I can tell you about some of the issues on which we focused in the proposed revisions to the guides that we put out for comment last year.
Sure.
They include changing the definition of endorsements so that it includes fake reviews and virtual influencers, saying that spreading fake negative reviews about a competitor is deceptive, clarifying that tags in social media can be endorsements, adding a definition of clear and conspicuous, saying that a platform's built-in disclosure tool might not be an adequate disclosure, better explaining the potential liability of advertisers, endorsers, and intermediaries, giving examples of the types of relationships that can constitute material connections, indicating that a material connection can exist even when the advertiser just provides an influencer with a free product and doesn't actually require an endorsement, acknowledging that some connections may be too insignificant to matter, clarifying that the disclosure of a material connection does not require the complete details of the connection. The FTC also proposed prohibiting advertisers from manipulating reviews, whether through procuring, boosting, organizing, or editing them in ways that distort or misrepresent what consumers think of the products. For example, review gating is when a company solicits customer feedback and then sends satisfied and dissatisfied customers down different paths to encourage positive reviews and avoid negative ones. We said that review gating may be a violation if it results in the posted reviews being substantially more positive. The commission also proposed adding an example saying that it's deceptive for a third-party review website to accept money from manufacturers in exchange for higher rankings. Another proposed example explains that incentivized reviewers should disclose that they received incentives. Giving such incentives would only be okay if it was clear to the reviewers in advance that the company wouldn't retaliate for them writing honest negative reviews. Also, even with disclosures in individual reviews, incentivized reviews could still be deceptive. For example, if they result in a materially increased average star rating for a product. And last but not least, I'm going to mention, another example says that reviews by employees should disclose their employment relationship, in that if their employer actually asked them for the reviews or had reason to know about them, their employer should monitor the reviews and take steps to ensure compliance.
Thank you, Michael. That's a lot to digest.
It is.
A follow-up is, what guidance can you provide to us on fake and false reviews? And should companies vet the reviews for accuracy?
Regarding fake reviews, the answer is don't do it. A company isn't responsible for all false reviews, but is responsible for those it incentivizes. Companies shouldn't do anything to encourage reviews that aren't true. Companies can ask customers for reviews, but they shouldn't take actions that bias or distort those reviews. Should they vet reviews for accuracy? Unless the reviews are incentivized or by company employees or promoted by the company, I don't think it's their obligation to do so. That said, it would be beneficial to the public if truly fake or false reviews were removed. Because of Section 230 liability, if a company is simply a publisher of consumer reviews that happen to be fake or false.
Got it. Michael, let me ask you this. The FTC has sent notices of public or penalty offenses, I guess it was to more than 700 companies concerning the triggering of civil penalties for their potential use of fake reviews or other misleading endorsements. Can you share with us what are notices of penalty offenses and what's the goal of sending out these notices?
Sure. The FTC may notify companies that certain acts or practices have been found to be deceptive or unfair in litigated administrative FTC decisions. We can then, under the FTC Act, bring an action for civil penalties against any company that receives such a notice if it then engages in the same conduct the notice says is unfair or deceptive. The civil penalties can be a lot. They can be over $50,000 for each violation. The notice about reviews and endorsements covers a number of unlawful practices you mentioned, falsely claiming an endorsement to be by a third party, misrepresenting that it reflects the experience or opinions of users, continue to use an endorsement when you don't have good reason to believe it's the endorser holds those views, using endorsements to make false performance claims, fill and disclose material connections, or making deceptive typicality claims. And you asked about the goal. The goal of sending out notices is to reduce the use of the unlawful practices and to establish a basis for getting civil penalties against companies that engage in them.
Got it. Got it.
I mean, we're also, so in the endorsements and testimonials area, the NPO applies to anybody who received it. We're also issued an ANPR about a potential rulemaking involving fake and false reviews, which would apply to anyone, whether or not they received a copy of the NPO.
Michael, companies may view any harm to a consumer as speculative, as in most cases with deceptive reviews, there's often no allegation that the product or service did not perform as represented. So how does the FTC calculate the harm that results from deception in this space?
Sure. Even if there is no allegation that the product or service did not perform as represented, we believe that there is consumer harm from fake or inflated reviews. Consumers are buying products or services that weren't as well liked or regarded as they were led to believe. We have various ways of looking at and calculating the harm from deceptive reviews, but I'm not going to share a formula. The number of purchases and their cost can certainly be factors. Yeah.
Got it. Obviously, the commission has taken an aggressive and a vigorous enforcement approach in this endorsement and testimonial space. There's obviously a distinction or a line between an actor speaking independently and a sponsored advertising message. Is it the FTC's position that a platform holder should actively monitor the particular user of that platform?
The consumer protection authorities in the United Kingdom asked Facebook to monitor and shut down Facebook groups that were buying or selling or trading customer reviews. And I think it's a reasonable request. Should a review platform do any monitoring of the reviews appearing on the platform? Speaking only for myself, I think that they should, but that's a different question than are they legally responsible for doing so?
You're just talking about prudent compliance, if you will, then?
I'm talking about being good to their readers and to consumers to use their website. It's the right thing to do, but not that it's illegal under Section 5 of the FTC Act, or at least reachable by us if they don't.
Got it. How does all of this overlap with the FTC's revisions recently to the health products compliance guidance? Have you all seen an uptick in enforcement within the health product space?
Well, in 1998, FTC staff proposed guidance on how to ensure, actually, no, I'm sorry. We actually provided guidance on how to ensure the claims about the benefits and safety of dietary supplements were not misleading. Last December, FTC staff updated that guidance. I personally worked on it. How does this overlap with endorsements? Well, in both areas, we're trying to update guidance to reflect our latest thinking. And the health claims compliance guidance includes updates regarding endorsements and testimonials, and an updated definition of clear and conspicuous, similar to the proposed definition and endorsement guides. But beyond that, there isn't much overlap. Let me take a minute and tell you about some of the other changes to our guidance. One of the major changes is the title, which makes clear that the guidance applies to all health-related claims. We've also incorporated 11 actions challenging deceptive health claims since 1998, and from other FTC guidance documents like an enforcement policy statement on homeopathic drugs that I also worked on. There are new examples related to foods, over-the-counter drugs, devices, and other health-related products. The guidance document discusses the difficulty of making qualified claims. What we mean by a qualified claim is one with limitations or caveats. The guidance now says that most health-related claims require high-quality, randomized controlled human clinical trials. The guidance document discusses proper testing methodology, including control groups, randomization, blinding, statistical significance, and clinical significance. It cautions against p-hacking, that is selectively relying on analysis of small set of data after failing to find a treatment effect in the study population at large. It explains that how we look at the totality of the evidence and not just one study in isolation, and how the evidence must support the claims that are actually being communicated. The document says that the Deshay disclaimer, which I'm sure you and probably your audience knows, these statements have not been evaluated by the FDA. That doesn't absolve one of potential FTC liability. You asked whether there's been an uptick in enforcement within the health product area. I don't know whether I would call it an uptick, but we do have 7 COVID-19 health cases in litigation, or that were litigated and are now concluded. Also, there were health counts in several recent cases that focused mainly on other violations involving either the mail order rule or made in the USA claims. And if you add in the other non-COVID cases currently in litigation or recently announced in my division, Zycal, Stem Cell, AwareMed, and Quincy, I think we have a pretty full plate of health cases at the moment.
Sure. Thank you. I'll let now, we'll switch topics to influencer marketing, and I'll let DeMorris take over.
Thank you, Tony. And thank you, Michael. And so, yeah, so we'll jump into influencer marketing as well as promotional devices in the social media space. And a question that I get asked routinely by clients who are using endorsers or influencers, whose obligation is it to disclose any material connection between the brand and an influencer or endorser? Is it the brand and the company? May there be other third parties who may also have a disclosure obligation?
Yes, it's the responsibility of the brand, it's the responsibility of the agency or the marketing partner, it's the responsibility of the influencer. All of them could be held responsible and could be held liable. So far, we've focused on the brand or the agency, but that doesn't have to remain the case. We could go after individual influencers.
And in terms of disclosures, what are the rules? I guess, are there any distinctions that we should think of when it comes to disclosures by the various channels, whether it be Twitter, Facebook, Instagram, YouTube, or even live content?
I don't know if you're talking about the built-in disclosure tools offered by some channels? If so, we'd caution not to rely upon them. I mean, the channels themselves are not responsible for making disclosures. So I'm not exactly sure if that answers your question.
No, that does. I do think, I guess my question more too is, should brands, when they're thinking of disclosing, or influencers or all of the parties who have disclosure obligations, should their types of disclosures vary by platform potentially?
Oh, yes, they should.
Perfect.
And
then
we,
I guess, go ahead, sorry.
I mean, we give some guidance on that in our FAQs, and we're going to update the FAQs probably after we update the endorsement guides. So we'll have updated guidance on that. But I mean, on Instagram, for example, we've had cases where we said consumers shouldn't have to click on the more button in order to see the disclosure. I mean, if a claim is being made in a video, the disclosure should appear in the video too. I mean, yes, I mean, in how you make a disclosure depends on what the media is. A live stream, somebody could tune in at various points, and if there's endorsements throughout, then there should be disclosures throughout.
Yeah, understood. And so, relating to disclosures and the platforms, do the social media platforms have an obligation to monitor users that they are known or that are known for using their account to push products or brands?
I don't know of any such obligation.
Understood. And so next, let's move on to promotional devices. So sweepstakes and the likes that are routinely promoted in social media. Any thoughts on disclosure obligations as it relates to promotional devices in social media?
Sure. I presume that you're asking about social media sweepstakes that in order to enter, people basically need to post a product endorsement to their social media stream. Viewers of such posts should know that the posts were made in order to enter a sweepstakes. Obviously, one could say something like, this post was made in order to enter a sweepstakes, so that's pretty long. We previously said that a hashtag like, XYZ_sweepstakes, where XYZ is the brand name, should be good enough. A brand should also instruct participants who enter the sweepstakes to make the disclosure show that it's clear and conspicuous. For example, at the beginning of the post.
Understood. And so in the interest of time, we'll stay with social media, but we're going to transition into, I guess, some of our newer technologies and the metaverse landscape. And my first question there are, what new developments in social media technology or marketing practices are happening that are of interest to the FTC?
Well, we have concerns about artificial intelligence, also known as AI. Congress has defined AI as a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. We have three main concerns about AI. Fraud, deepfake and other AI-based synthetic media are becoming easier to create and disseminate, which poses major risks, especially around fraud. The rise of sophisticated chatbots carries similar risks, even though they may hold promise. The FTC has already seen a staggering rise in fraud on social media, a rise we attribute in part to the use of sophisticated algorithms designed to target us with ads. AI tools that generate authentic seeming videos, photos, audio, and text could supercharge this trend, allowing fraudsters greater reach and speed to engage in imposter scams, identity theft, payment fraud, fake website creation, and otherwise steering consumers into making harmful decisions. Dark patterns. In a similar vein, we are already seeing firms deploy A/B testing, eye or mouse tracking, and other techniques to develop dark patterns designed to manipulate consumers. What especially concerns us is the use of AI design and refine these techniques to further manipulate consumers. And third, discrimination. Algorithmic decision-making can be useful in mitigating human bias, but we have serious concerns that can instead replicate and entrench such bias. Unrepresentative data sets, faulty classifications, and flawed design can lead to discriminatory outcomes, a concern also expressed by NIST, DOJ, and other agencies. These outcomes can have grave consequences for consumers, including being denied healthcare, housing, or employment. Last, I'd like to give a shout out to my colleague, Mike Atlason, who wrote a business guidance document, keeping your AI claims in check, and advise your audience if they care about AI to take a look at that piece.
Perfect, very helpful. And I guess as we talk about evolving technologies, how does the metaverse or metaverse related advertising fit into the equation as the FTC looks to protect consumers?
Sure. As far as I'm aware, we have not said or done anything specific to the metaverse. It just fits in like any other venue, real or virtual. All of our basic advertising laws and principles apply, and we will apply them as needed. If special issues or a need for special guidance arise, we will address those issues.
Perfect. And last on our technology front, the FTC recently launched a new Office of Technology with the goal to keep pace with technological challenges in the digital marketplace. Can you comment on the duties or the role or what the FTC is looking to fulfill with this office?
Sure. This year, the Office of Technology will better equip the agency to approach current and future tech threats by building a team of technologists with deep expertise across a range of specialized fields, including data security, software engineering, data science, digital markets, artificial intelligence, machine learning, and human-computer interaction design. The top priority is to work with staff and leadership across the agency to strengthen and support the agency on enforcement investigations and litigated cases. This could mean dissecting claims made about an AI-powered product to assess whether the offering is oozing with snake oil, or whether automated decision systems for teacher evaluations adversely impact employment decisions and make inferences that impact compensation and tenure. It will keep a finger on the pulse of business model changes like shifts in digital advertising ecosystems to help the FTC better understand the implications on privacy, competition, and consumer protection. It's tracking emerging technologies like augmented and virtual reality, where their immersive environments provide new types of data and ways to collect, use, and make inferences from it. Beyond enforcement matters, the office will serve as subject matter experts to advise and engage with FTC staff and the Commission on policy and research initiatives. Our Office of Congressional Relations may need to gather intelligence for an upcoming bill or policy research, whether it's deciphering the latest applications of blockchain or unpacking unfair design practices that can cause substantial physical and other injuries to minors through features that aim to maximize engagement and data collection.
And so next we'll transition to the .com disclosures and digital advertising.
Sure, thanks. Thanks, Demorse and Michael. Michael, what is the status of the FTC's review of digital advertising?
Well, with respect to .com disclosures, staff solicited public comment, and we are currently reviewing the public comments received, and we'll make proposals for revising the document. I can't say when that will happen. Make proposals to FTC management.
Sure. Are there any key takeaways from the workshop of last May that you can share with us?
I'm really not sure which workshop you're talking about.
I think there was a workshop relating to or some kind of forum on the .com disclosures or digital advertising. Maybe my time frame is wrong.
No, there was no workshop on .com disclosures. There was a workshop the prior year about dark patterns, if that's what you're talking about.
Go ahead and talk about that. Might be what I'm thinking of.
Okay. Well, we had a workshop in, I believe, 2 years ago, and we issued a report bringing dark patterns to light. That report is posted to the FTC website. A few examples of things we say in that report are to comply with the FTC Act, companies should make certain that their online interfaces do not create false beliefs or otherwise deceive consumers. The company should be upfront about all material terms. This means don't bury key limitations of a product or service in dense terms of service documents or hide fees where consumers are unlikely to see them before purchase. Companies should make sure their procedures for obtaining consent included an affirmative, unambiguous act by the consumer. And last but not least, with respect to cancellation, negative option sellers should provide cancellation mechanisms that are at least as easy to use as the method the consumer used to buy the product or sign up for the service.
You know, that's a recent initiative you all are doing on negative options. I know this next question is going to be a mouthful, but what kind of guidance can you provide us now on preventing digital deception?
Well, I kind of just covered those things. I just basically outlined those.
Got it. Got it. Trying to get as much as I can from you, Michael.
Sure, no problem.
I'll turn it over to Demoris now for Made in the USA claim.
Sure, sure. So, Michael, you mentioned Made in USA in passing earlier, and obviously it's a topic that I'll concede I probably get at least 2 or 3 emails a week on Made in USA from clients, and particularly with the new Made in USA labeling rule. And regarding, are there, I guess the questions I get are, are there new obligations? What should we be looking for? What should we be doing? And I guess at a high level, what's the takeaway from the enactment of the Made in USA labeling rule?
Well, there aren't new obligations, it's just a new impact. The Made in the USA labeling rule codified the Commission's longstanding interpretation of Section 5's requirements governing substantiation for unqualified Made in the USA claims. Specifically, the rule prohibits unqualified Made in the USA claims on labels unless 1, final assembly or processing of the product occurs in the United States, 2, all significant processing that goes into the product occurs in the United States, and 3, that all or virtually all ingredients or components of the product are made and sourced in the United States. All 3 must be true. The rule makes a broader range of remedies available to the Commission, including civil penalties.
Thank you. And so I guess if there was a message for brands regarding the FTC's recent uptick.
I mean, do you want me to tell you?
Oh, you froze for a second there.
I'm sorry. We continuously monitor the market for false Made in the USA claims, and we're bringing cases. Last year, we brought our first 2 actions under the rule, requiring sellers of deceptively labeled lithium-ion batteries and of PPE, personal protective equipment, to pay significant penalties. In the battery case, the civil penalty was triple the profits on the sales of the deceptively marketed batteries. In the other case, under the rule, we obtained a civil penalty and a suspended redress judgment based on the sales of the falsely labeled products. We also brought 2 enforcement actions against companies making false claims for imported textile products. One company relabeled imported apparel products as Made in the USA, and the other imported bedding products pre-labeled as Made in the USA. We also sued a manufacturer of glass baking products for continuing to advertise its products as Made in the USA during a shift to overseas production at the height of the pandemic. The message is that marketers that make deceptive US origin claims can expect consequences.
I appreciate it. And then next, I'll turn it over to Tony.
Great. We'll now get into enforcement actions and remedies concerning digital deception, fake and manipulated reviews, and violations of the guides. Michael, the Commission brought an action against Bountiful Company and obtained a judgment of what, some $600,000. It involved review hijacking. And my question is, can you tell us what review hijacking is, and do you see other tactics that's giving you and your colleagues concern right now?
Bountiful was actually my case, and review hijacking or review reuse fraud is when a company repurposes reviews for one product to appear to be for a different unrelated product. I mean, it could be that they use a review for a honey and make it appear that it's for an iPhone charger. In Bountiful, they used it for products with different ingredients or different formulations, and we think that's deceptive.
Got it. How did the Commission get the money, the monetary? Oh, go ahead. I'm sorry. No. I mean,
you did ask whether there are other tactics of concern, and I wanted to answer that too. We're concerned about other practices, whether it's review gating, review suppression, manipulative upvoting or downvoting of reviews that distorts what consumers think about products. And giving incentives for reviews could also be distorting, as I mentioned before.
Thank you. I got it. How did the commission get the monetary relief of $600,000?
Sure. I mean, we alleged deception and we obtained consumer redress. The commission still has the ability to obtain redress through a follow-up Section 19 action, and someone can settle to avoid such an action.
Got it. Got it. Stepping back for a second, Michael, what's the outlook for investigations concerning digital deception, fake reviews, and violation of the endorsement guides? Can you give us kind of a bird's eye view of what you all are looking at right now? What's the outlook?
I mean, those are areas in which we're highly interested and where we are always on the lookout for possible cases. I mean, what else more can I say?
Well, you know, we've got folks in the audience that, you know, in different industries and, you know.
I mean, if they want to report a competitor to us, we're happy to hear it.
Okay. Well, let me ask you this then. What factors lead the staff or the commission to commence investigations? What triggers investigations?
Sure. There are many sources for investigations, including consumer complaints, complaints from competitors, which I just mentioned, information from former employees, had a couple of those recently, information from advocates or others focused on an area, press articles, congressional inquiries, staff-generated sweeps or inquiries. Some investigations of an issue start from an investigation of a company for an unrelated issue. I've had that recently, as have others. And sometimes staff sees or hears something that just catches our attention. As far as which cases we choose, it depends on a number of factors, including the extent of consumer injury, whether practice is national or local, whether it involves health or safety, whether it's novel, and whether we want to send a message in an area.
Got it. I know when I was at the commission, I was always interested in trying to leverage our resources. Obviously, right now, the commission has a lot on their plate, you know, in terms of the volume of work you're doing, the number of issues you're facing. What kind of cooperation are you getting, or are you seeking cooperation from the state attorneys general?
Given the AMG loss of our ability to get disgorgement or redress through 13B, we have been coordinating with state AGs to use their general civil penalty authorities. One such case in which I was personally involved was our iHeart and Google settlement, which was announced last November. We coordinated with 7 AGs and the companies paid them a combined $9.4 million. I expect that we will continue to engage in such joint actions going forward.
Got it. The commission, I guess it was somewhat recently, released its data collection on the marketing of cigarettes and smokeless tobacco. Are there other industries of interest that you're focusing on in terms of their marketing practices?
Yeah, sure, there are. Last month, the FTC issued 6B orders to 8 social media and video streaming platforms, seeking information on how the companies scrutinize and restrict paid commercial advertising that is deceptive or exposes consumers to fraudulent health claims, financial scams, counterfeit and fake products, or other fraud. The orders were sent to Meta Platforms Inc., Instagram LLC, YouTube, TikTok, Snap, Twitter, Pinterest, and Twitch. The commission is also seeking information from those companies about how they ensure that consumers are able to identify commercial messages on their platforms as advertising. And at the same time, the FTC launched a separate inquiry with separate 6Bs into small business credit reporting industry, ordering 5 companies in that industry to provide the commission with detailed information about their products and processes. The orders were issued to Dun & Bradstreet, Experian, Equifax, and Sony Credit Data, and CreditSafe USA. Unlike credit reports for individual consumers, which are governed by the Fair Credit Reporting Act, there's no federal law that specifically outlines processes and protections available to small businesses when it comes to credit reporting. This can make a business credit reporting hard to understand. and it can be particularly difficult for small businesses to navigate how to correct errors and omissions in their credit reports in a timely fashion. Business owners may not even be aware a report about them exists. Sometimes small businesses only discover that they have a credit report when they are denied credit by a supplier.
Mhm.
The Commission's inquiry will examine multiple aspects of how information is collected and processed for business credit reports, how the reports are marketed, and how and whether the credit reporting companies address factual errors in the reports. In addition to information about these topics, the orders also require the companies to provide information on services they provide to businesses to monitor or enhance their own credit reports.
Thank you. I want to be sensitive to your time and everybody else's time, and I want to thank you so much. This has been very, very useful, a lot to digest, and we certainly may be getting back to you on any follow-up questions. Are there any kind of closing remarks or thoughts you'd like to share with us before we end the program today?
It's been a pleasure being with you here today, and thank you for your time and your attention.
Well, thank you so much, Michael. We really appreciate the good work that you're doing, you and your colleagues, and we really appreciate the opportunity for you to come to speak with us. And I wish you and your colleagues a good day, and I want to wish the audience a good day as well. And may all have a healthy and happy week, end of the week and weekend, and continued success and good health to everyone. Take care. Thank you all so much.